Okay, Shaun, I think we've got most of our registered participants online, and we have a very, very interesting topic today with a lot of information to discuss. So I'm not going to leave it any longer. Welcome everybody this morning to the Tshwane Tourism Association Labour webinar. We have Advocate Shaun Gresse, who is a labour specialist, a labour law specialist, here this morning to give us some information and fill us in on the background of a lot of the matters that are pertinent at this time: employment contracts, the employment relationship, tendering of services, the employer's obligation, application of principles. What do you do about retrenchment and how do you go about that? And is it your first or your last resort? Business survival options post-COVID-19, unions and how to best facilitate those relationships during this time, the mandatory sick leave related to COVID-19 and compensation claims related to COVID-19. So without any delay, I'm going to hand over to Advocate Gresse, and we thank him very much for giving us his time today. It is a very valuable time, and we are very, very privileged to have you with us. So welcome, Advocate Gresse, Shaun, and I'll hand the floor over to you. Thank you.
Thank you, Bronwyn. Thank you for the panel. Thank you of Tshwane Tourism Association having me this morning and to be able to present to you a few answers to numerous questions that everybody has. I've designed the info session this morning in such a manner that everybody will be able to have their questions answered in terms of business survival post-COVID. Aside from any adverse economic, health and social impact of the COVID-19 crisis on people generally, employers are also confronted by complex legal issues and facing several employment challenges and business survival after lockdown. My solidarity goes out to everybody in the hotel and tourism and catering industry that has been severely impacted in this environment and the economical strain that everybody is under. And of course, the employees and responsibility that a business owner has towards his employees, towards his shareholders, and towards any other supplier that he might have. And many questions arise out of the situation. The legal issues arise as a consequence of the restrictions on economic activity imposed in terms of the Disaster Management Act of 2002, not only during the period of hard lockdown, but also thereafter. The challenges employers are faced are numerous. For example, an employer who is unable to provide work as a result of the restrictions imposed on their business continue to pay its employees? Question 1. Question 2. Can an employee who is prevented from tendering his or her services because of the restrictions demand payment from the employer? Question 3. And what if the restrictions are lifted and employees tender their services, but their employer is unable to utilize their business or their services because their business is not functioning or fully operational? Now, those are some of the severe questions that's been asked around. And of course, the underlying backdrop of this is, should I start with retrenchment proceedings, or should I start with redundancy, or should I start with short-time procedures? All those I will explain shortly. Impossibility of performance in terms of ordinary principles of law of contract. A contract automatically terminates when it becomes permanently or objectively impossible for the parties to perform their obligations due to no fault of their own. Should this happen, all parties are immediately released from their obligations. If the impossibility is merely temporary, as the case in this lockdown and the easing of restriction, or other restrictions that are being beyond the control of the parties, the mutual obligations are only suspended for the period of impossibility. The employment relationship, in a nutshell, how does this apply to employment relationship? The employer's primary obligation to the employee is to tender his or her services. If the employee becomes permanently incapable of tendering his or her services, this obligation is extinguished, as is the employer's obligation to pay, aside from outstanding sick leave or holiday pay. However, unless the relationship is terminated by an agreement, subject to the conditions of the Labour Relations Act, Code of Good Practice on dismissals or incapacity operational requirements, if the employee's inability is merely temporary in nature because of legislative frameworks or restrictions imposed, like we're having now, the restrictions in our economy based on the Disasters Management Act, no work, no pay principle applies. The employee will, however, have recourse to the UIF support, which we all know is TERS. Incidentally, TERS will be ending, and no more payments will be made. There is no rumors or any suggestions from the Labour Department that any further payments extension of 3 months will be granted. So UIF support will only be allowed for people that are being dismissed for operational requirements, i.e. retrenchments, short-term contractual ending, for instance, limited duration contracts that have ended, or dismissed for misconduct. No other payments will be given to them. So that normal application process needs to support. Ending of services, except in very exceptional circumstances, the employer's obligation is not to provide work for its employees. We don't have the right to work, but to pay them if they properly tendered their services. The employer must be able to tender his or her services legally, which is not possible if the employee is prohibited by lockdown regulations or other restrictions from doing so. Later on, I will allude to sections 24 to 45 of the Occupational Health and Safety Act and COVID-19 regulations. Foreseeable danger for employee to refuse his or her duties. I'll revert back to that just now. If the employer is unable to utilize the employee's legally tendered services because of restrictions, the employer has still the obligation to pay its employee or employees for as long as his or her services are available to be utilized. If the employer wants to avoid this obligation to pay, will need either to reach an agreement with the reduced working employees or reach an agreement with the union. In terms of this, and this will constitute changes in terms and conditions of employment. However, the employer will need to justify this. Merely because it's unable to use employee services, it will need to demonstrate proper operational requirements in terms of the LRA. Scenarios that I've sketched that might be applicable in the industry. Scenario number 1. The employee is in the performing arts industry and the current level of restrictions prohibits public gatherings. The business thus cannot operate at all. It wants to retrench all its staff. The proper procedure needs to then be followed, notification to all employees, and employees then need to follow section 189, consultation and retrenchment process needs to follow suit, unless your operational requirements is of such a nature that you can place all these employees on temporary layoff that suspends their salaries for a duration of time until at such time you're able to perform, able to operate as a business. Scenario number 2. The employer repairs tents or trailers. It may not operate at all under the current restrictions, but is confident that business will return to normal, close to normal when summer arrives. It intends to make use of opportunity to reduce the employee numbers by retrenching some of its staff and temporarily laying off others without pay. Exactly the same there. Normal procedure needs to be followed, section 189, or if there's terms or conditions of employment that's to be changed, agreement between the parties must be reached. If an employee unreasonably refuses the new proposed terms or conditions of employment, retrenchment proceedings can commence. Scenario number 3. The employer manufactures labels that are used in a variety of industries, hospitality industry, etc. In terms of the current restrictions, it may scale its operations up by 20%. It is now practical and profitable to open it all. It intends to retrench all staff or now with a new possibility of re-employing some of them several months from now on. An agreement can be reached between the parties for temporary layoff or retrenchment with an agreement that if the business picks up more capacity than 20%, I will then contact you directly and then of course I will re-employ you. Re-employment can happen on 2 ways, new negotiated terms and conditions of employment, or on the same terms of employment that previously existed. Scenario number 4, if the employer has a restaurant, which means that it may not open its doors or sit down to customers as the previous regulations dictated. Now it is dictated that they are allowed to have customers in with extensive protocols and screenings and legal requirements surrounding the COVID. It may, however, at the capacity of 75% or 25% or 50%, the normal operating hours. You don't have any work for your waiters. You can also have the waiters being temporarily laid off, and or your kitchen staff and or assisting managerial staff. Changing in terms or conditions can be negotiated between the parties. Sit down, have a meeting. Operating hours are changing. Their salary structures are changing, of course. Or retrenchment proceedings can then ensue, and proper notification can be given to everybody in terms of Section 189. These are the scenarios typically that will manifest itself. Now, typically, as I've learned over the years, and everybody can dictate to that, is that your own business, your own protocols dictate a set of unique merit scenarios which needs to be digested and entertained, and obviously the best way forward would, in line with the LRA basic principles, would apply. The application of these principles are as follows. In the scenario sketched above that looms in the background is a possibility of retrenchment. Turnout, retrenchment is a possibility. It would be prudent for a business or any business owner to prove that he's followed all reasonable steps prior to retrenchment to curb job losses. Based on the current situation that we have, and the COVID-19 CCMAs and labour courts alike would be reluctant to grant or condone retrenchments if the company has not considered alternative options to retrenchment, i.e. short time, changing terms and conditions of employment, a temporary layoff, or different attendance rosters where employees can be rostered around in different time slots. If you can demonstrate that you've done all the above, and you've attempted not to shed jobs, then retrenchment would be the only option, provided that you follow the basic principles of retrenchment, i.e. Section 189 retrenchment procedures, in line with the Code of Conduct and Code of Good Practice, Schedule 8 of the LRA. Scenario as follows: employees unable to tender services, where employees may not tender their services, performing arts or hotel and catering industry perhaps, or any other manufacturing industry where, or for instance, they cannot tender their services, then the continuation of the temporary their performance is impossible. Then their employment relationship is suspended temporarily until such time the lockdown or the restrictions surrounding that business comes to an end. So no work, no pay principle applies to those employees. Of course, they have the option to claim TERS relief fund. Without any extension of the TERS relief fund, alternative measures need to be taken, which I do not know at this point in time, to assist those employees that cannot claim TERS further in the businesses in restriction, like Virgin Active and all the other gyms that we have in South Africa. Employees able to tender their services, where employees are able to legally tender their services, fully or partially, the employer remains responsible for paying them their normal salary until such time as they have come to a different agreement. And let me repeat that again. It's really important. The employers are able to legally tender their services, fully or partially. The employer remains responsible for paying them normal remuneration salary until such time they have come to a different agreement. And the different agreement is changing terms and conditions of service, sitting down with employees, say, I'm not able to accept your legally tendered services at this time based on operational requirements or financial requirements. Therefore, need to come to a further conclusion in terms of your employment relationship with the company. And that is changing his rate per hour, his working hours, and his holiday, etc., or leave periods where the employee is accommodated and the company is also accommodated financially. If unions are representative in the workforce, obviously then a consultation with the unions should ensue, proper notification should be given, and then agreement between the parties should be then reached. If there is a deadlock between the parties in terms of agreements, both parties have the right, in terms of the LRA, refer the matter to the relevant bargaining council or CCMA for adjudication. If the employer wants to extend a temporary layoff or reduce working hours, it amounts to change terms and conditions of employment, and such changes obviously then needs to be agreed upon Noteworthy to point out, you cannot change the terms and conditions unilaterally. There must be consensus, a meeting of minds between the parties. Negotiated short time or layoff. Employers should, where appropriate, offer alternatives such as short time. Teaching staff in scenario number 4 and the service employees in the production, manufacturing industries and other in situations of temporary layoff would be more appropriate in permanent retrenchment. This is based on operational requirements of the company, whether they are able to place on the table temporary short time or extended period of layoff. If they're in the position to expend extended period of layoff, then no work, no pay principle applies until such time the company can re-engage and start up again. If it is not possible, and you've exhausted all other remedies in terms of the employees not sharing work, and retrenchments is in the background, an elephant in the office or in the room will come to forth, and the normal procedures of retrenchment then would then apply. Redundancies or retrenchment. Redundancies are very likely to arise as a result of the imposition of restrictions. However, in most cases, it would be sensible for employers not to rush into retrenching staff immediately. It may be a better option, if possible, to hold out to re-evaluate the situation at a later stage. Short-time or temporary layoff arrangements would provide employees some hope, and employer may avoid having to pay severance packages. In the meantime, employees would have access to UIF or TIS benefits. If an employee does decide to retrench, the court or CCMAs will be in event inquire as to the employer's reasons for not considering such alternatives. Given the hardship of the current crisis and situation that we are under, that would be prudent for all business owners to canvass all the possibilities before embarking on a retrenchment process. Noteworthy to point out, business efficiency. Business efficiency falls directly on the feet of the directors of the company in cases where employers' main concern is the survival of the business or optimal efficiency, and where short-time or temporary layoff are not considered to be viable alternatives. The employer is still bound to show that retrenchments are operationally justifiable, as we all know. In terms of Section 76(2)(a) of the Companies Act, a director of a company must use his proper position as a director or any information obtained while acting in a capacity as a director, not knowingly cause harm to the company or subsidiary companies. In the event that the company reopens their doors and the director causes direct harm, allowing the business to run at a loss, the director may be declared delinquent under the circumstances prescribed in Section 162(5). Furthermore, in terms of Section 76(3), a director of a company, when acting capacity as a director, must exercise the powers and perform the functions of a director in good faith and in the best interest of the company, and with a degree of skill and scare diligence that might reasonably be expected of a person in that position. I have described the process in terms of what is the legal stance in terms of legally tendering services, retrenchment process, alternative positions in the workplace. It also needs to take into consideration the following circumstances. If an employee legally tenders his or her services and the company accepts the tendering of that legally services, it becomes apparent during the operation or during the employment tenure that there's an imminent and serious risk of exposure of COVID. And the employee can refuse his or her services immediately. The question then arises who then pays for this situation where the employee has commenced duties legally, tendered the services legally, the company has accepted these services, but there's an imminent or serious threat of exposure to COVID-19. Obviously, the provisions of Section 24 to 45 of the Occupational Health and Safety and COVID direction needs to be followed. And those of you that are familiar with it, it is record keeping, screening, sanitization, decontamination, screens, masks, etc. If the employee is of the objective view that the employer is not complying with the provisions set out in clauses 24 to 45 of the OSH COVID-19 direction, he can then obviously refuse his services. Then the matter has to be resolved by the Occupational Health and Safety Inspector that each and every company must appoint, And if the situation cannot be resolved by rectifying the objective discrepancies that might appear, objective, I mean, there's not enough sanitization, or there's not a screening device, or it is in such the workspace or social distancing of such a nature that no one can work together in a safe environment, an occupational health and safety person must rectify it. If there is a deadlock between the parties in terms of that, the matter then can be referred to the CCMA for adjudication, and that will be classified as matters of mutual interest. The matters of mutual interest would then entitle the bearer of the certificate to strike and force the company to comply with the provisions. The knife cuts both ways. The employer can also refer the matter to the CCMA for adjudication of the matters of mutual interest, because the employees also made his life or working environment intolerable by not following the rules and the directives that's been placed before him by the company for safety and health and safety protocol reasons. I fear in the future that we might be having a situation where unions or parties refer the matter to the CCMA as a matter of mutual interest, as an objective, imminent and serious risk of exposure, and then compile a shopping list for other reasons to embark on an industrial action strike. This is very uncharted territory. Only the CCMAs and courts will then guide us with this, but it's a possibility at this point in time. Bronwyn?
Thank you, Shaun. Would you like to go through the questions that were posed by the attendees when they registered for the webinar? Or would you like...
One of the questions that I did see there, will the TERS extend their fund or fund benefit? As we speak, as of now, there is not any rumors or any declaration that the TERS benefit will be extended whatsoever. We're not aware of that. My company, SIG Labour, is willing to assist everybody with applications for the TERS benefit fund if they have not submitted theirs already. As it stands, the only other remedy that the employee then has, if he's been retrenched, is the UIF contribution application that he needs to submit for times that he's been employed by the company on a scale. They'll allocate funds to the employee for his relief. However, he is not able to claim any UIF contributions if he resigns from his position.
It is unfortunate that TERS is coming to an end. The Tourism Business Council of South Africa has indicated that they will be negotiating with government on our behalf to try and get a fund allocated specifically for the tourism industry, as the effect is so intense for our industry, being one of the last to be able to open, and because of the lack of demand that we're seeing. But that all remains or rests on whether or not government actually has available funds to allocate to such a scheme. Apparently there are other TERS schemes within UIF, and hopefully one of those can be leveraged, but we will keep our communication open regarding that.
I see there is a question, Bronwyn, regarding the minimum wage requirements. Is the minimum wage still applicable in these conditions? As we speak, it is still applicable. It's not been repealed. The 3,500 per month minimum wage does still apply, and all the other bargaining councils' minimum wage requirements still apply. However, you have a remedy. You may apply then for exemption for the minimum wage, or the application of the minimum standard of payment to be exempted by the particular bargaining councils. There's an application that you make formally in terms of the National Bargaining Council Collective Main Agreement.
And Shaun, what is the situation if you want to change somebody's contract from full-time to a part-time, permanent, or to an hourly basis? Does the minimum wage still apply in that regard? Do you still need to provide that many hours work?
The minimum wage still applies, the minimum wage still applies, the hours of work, but it's changing in terms of conditions of employment. So a consultation between the parties is necessary. So everybody's need to sit down and understand that the minimum wage will remain the same, but his hours of work or terms and conditions, how he generates the minimum wage, changes. So consultation between the parties or meeting of the minds is necessary.
Okay.
I had a question there as well that someone asked whether you can terminate the person's contract or employee's contract if he's not performing adequate sales during the lockdown period. Now, it comes down to the passage that I've spoken about, impossibility of performance. If the restrictions of such a nature that the employee cannot perform his duties adequately or dispense his duties adequately due to restrictions posed by the National Disasters Act, termination of the contract is not so easily or simply achieved without the consent of the party. Normal process needs to be followed in terms of these deliverables, and he's unable to perform or travel during these restrictions that would be deemed unfair for his contract to be terminated.
That's understandable. We've run a poll to ask, have you considered retrenchments? 60% of attendees said yes, 26% of attendees said no, and 14% said not sure. If people are seriously considering retrenchment, how would you suggest that what would be the first step that you would suggest that they should take in terms of getting assistance to run that process if they don't have their own in-house HR specialists?
Well, my company, SRG Labour, is able to assist all employees, employers more specifically in that process, where we'll be engaging and facilitating that process. But most importantly, that one needs to understand is, and you can also do this yourself, is that you need to give adequate notification to both parties or the parties present in that process, i.e. a formal document indicating that you will be engaging in a changing terms and conditions or retrenchment process. And the most important criteria that needs to be complied by is what we call in the legal terms as odi alteram partem. Both parties needs to be placed in the position to present their case fairly and give their arguments in terms of why they believe they should not be retrenched or should not impose other conditions of employment, which is lesser than when they were employed.
We have a question. I'm aware of employees with high-risk illnesses such as HIV. Will you be seen as discriminating should you not want that employee back at work?
It's a positive obligation of all employers to look after the health and welfare of all the employees. That employee will be considered as an employee for comorbidity, a high risk of comorbidities, and therefore that employee needs to be protected by the employer. If he's able to perform his duties from work, from home, in a safe environment, he should do so. If he's not able to perform his duties from an environment offline at his house, then the company may engage them on terms and conditions, changing of those terms and conditions, i.e. alternatively short time or possibly retrenchment. But the obligation is on the employer to make sure that the well-being and welfare of his employees are being protected.
Shaun, what is the situation if you would like to get your employees to, or what is the process if you would like to get your employees to declare comorbidities, to provide them obviously you would need to provide them a list of comorbidities and ask them to declare, but some employees may still be reluctant to declare. What is the employer's liability there?
Well, the Copy Act also guides us there, but the employer has the right to know on the basis of the employment relationship if the employee does suffer from any form of comorbidities. However, the employee has a right and constitutional right to not disclose any form of illness or sickness that he might have. He can disclose to the employer that he might be suffering from a disease other than COVID, and that should be it, a medical condition as we know it in the medical certificate. Is a positive obligation on behalf of the employee to disclose this to the employer to make sure that the employer makes the working environment as safe as possible and understanding the risks associated to all employment relationships. At this point in time, we are very much on uncharted waters because it's privileged information that cannot be disclosed without a consent of third parties. And that information needs to be strictly garnered by the HR department and not disclosed to any other person. At this time, the employment relationship, the application forms or their CVs would be suffice to indicate whether they might potentially be subjected to comorbidities or such a high risk employees.
Thank you, Shaun.
It's a very difficult question to answer because there's so many permutations, and personal welfare and personal rights is also involved here. If the employee, of course, the employee might feel that it's important to disclose this to his employer, then he may do so. But that is under strict confidentiality protocol.
I think it's also pertinent at this stage, the relationship that you have with your employees will obviously play, and how much trust there is. One could probably also encourage one's employees to get a letter from a specialist appointed by the employer confirming that they don't have any comorbidities, or confirming that they have a medical condition but not divulging what that medical condition is.
They may do that.
Okay.
They may do that, yes.
One of our participants says, I'm considering short time but unable to do consultations due to restrictions and logistical issues. How do I approach this? That's very interesting. Is one able to do all of this over Zoom or Skype? Or
you may. There is now a Labour Court case that indicates that you may now conduct retrenchment proceedings via Zoom or any other platform similar than what we're having here today. It is difficult at times when employees at a low spectrum, market spectrum, where they are not able to access these type of platforms and have the data readily available, or the platform like a laptop to engage in this format. Other alternative, of course, is for the employee to come into the place of work. The sort of obligation and legal obligation from the employee is to make sure that the working environment is of a safe nature and complies with Section 24 to 45 of the Occupational Health and Safety COVID-19 directives. And in that case, the employee cannot reasonably refuse that offer, that instruction to return to his place of work and to conduct or commence the consultation proceeding.
We have another question. The consultations regarding short-time changing of salary conditions, etc., do these have to happen individually or collectively if there's no union involved? It would be very odd, this participant says, to negotiate changes to an individual's confidential terms of employment in a group setting.
It would be advisable to have the individual consultations because their salary structures and the personal information in terms of the employment relationship is confidential, and it would be advisable to do this individually rather than in a group.
Very interesting. Our next poll was, have you considered short time? 85% of the respondents said yes, 7% of the respondents said no, and 7% said not sure. So I think a lot of guidance is needed on the short time and how to administer that legally, and how to make that work best for the employer and the employee. We have another question, which is, while reopening, can some employees be asked to be on unpaid leave? Can they still get the benefit from UIF if they are on unpaid leave, but others are working?
Yes, as far as my understanding is, if they are and their employment are temporarily suspended, they can still apply for this relief. You have that payment, they can still apply. Yes, they can. Whether the payment will be made in time is a question of fact.
And I suppose the very difficult one is to choose who does come to work and who doesn't come to work.
Obviously, that's a fair process that needs to be followed.
Yeah, we've actually taken an approach at the CSR where we have people on different shifts. So everyone's got reduced hours, but everybody does get to work a little bit. But each situation is once again very unique.
Yes. Of course, every situation is unique and has to be evaluated on a merit. There's no one shoe fits all scenario. You got to evaluate the business operational requirements, the business needs, the amount of employees. It would be prudent for all business owners to sit down and say, what is the business going forward to, and how are we going to achieve this, and what employees are we going to take with us, and who gives a certain skill set that I cannot live without. And then based on that list and that determination, then mold your new business model accordingly, and the new changing in terms of conditions of employment. The emphasis is going to be given to a lot more working offline from home. People are going to be held accountable for their value add and their deliverables, all now in the past. But changing terms and conditions currently now is going to be one of the biggest aspects. And as I've said, both parties need to sit down around a table, discuss new terms and agree upon those terms. And if the employer refuses on these new terms, unreasonably refuses, then retention process can ensue.
Understandable. And I think also something which determines who works and who doesn't work these days, specifically in this month of July, where the cases of COVID are rising so rapidly, is who takes public transport, and is at more risk than people that have their own transport. Because your staff that are taking public transport, especially with the taxis not complying with the regulations, might be putting the business at more risk than staff that have their own transport. Our poll results for have you considered changes in terms of conditions is 73% yes, 18% no, and 8% not sure. So that's also, there's a lot of work to be done there. It's not simple to change the conditions of service of one's whole or part of one's workforce. We have a question that says, can the company be kept liable for shortfalls in TERS payments, e.g. minimum wage not being awarded by UIF through the TERS process?
Yes and no. Obviously, it's impossibility of performance, but it's also a situation where there's a shortfall. If there is a total restriction on working, employees cannot tender his services, then it's no work, no way principle applies, even if there is a shortfall from the TERS department. But if the company is able to perform its duties and continue, and it still applies for the TERS benefit, then the company is obligated to make up that shortfall and make sure that the employee is placed in the position that he was prior to the impossibility of performance, or at least prior to COVID. It's a very difficult answer that I've heard numerous companies saying that employees say that they have nicked their monies from TERS and that they've not paid over the correct amounts, and they now are responsible for the shortfall or the difference. And it's quite simple. If the company is unable to perform its duties during restrictive time, then no work, no principle applies. No pay, no work, no pay, so therefore they're not obligated to pay that shortfall. If they are currently operating, then there is a process of negotiation or meeting of the minds that needs to take place.
Thank you. We have a comment from, I would assume it's potentially a restaurant. Shaun, we have a scenario where one of our shops had to close down due to our sublease being terminated, as the company holding the main lease had terminated their main contract due to the COVID-19 pandemic. How do I handle the situation with those staff members at that specific shop, as I have no option of trading there at this stage?
Well, one or two options can ensue there. The first is a temporary layoff, where no work, no pay principle applies until other lease agreements are concluded, or they can change premises. The second option is redundancy retrenchment. Retrenchment procedure need to be followed. If there's no foreseeable future of the lease agreement being renewed or any other form of employment being generated, the retrenchment process needs to be followed. In terms of the LRA, of good practice, Schedule 8.
This is indeed a very, very worrying situation, and we just keep on hearing more of these stories every day. We have a comment. The majority of our business is based on international business, conferencing and liquor sales. Restriction under lockdown level 3 directly impacts the business, and therefore we cannot be fully operational. Can we thus extend the temporary COVID-19 layoff per a written notice to employees versus a mutual meeting and agreement with employees and union?
Yes, you can extend that because you're not in a position to fulfill your duties, and there is a restriction. The business cannot continue. However, you need to have a meeting with the union, and you need to have a consultation with the employees and a meeting of minds, a consensus, an agreement. In other words, that matter will be extended. You cannot unilaterally apply that.
Okay, so you do need to agree together with your staff and the union, if they are unionized, that you're going to
unionized. Correct.
Okay. And one can do that digitally over a digital platform.
You can do that on a digital platform. Luckily for us, the digital platform also records it, so the recording of it will be suffice.
I did. I was informed about a company the other day that held a staff meeting with all their staff, and some of the staff were not able to access the meeting at the time that it took place, but they recorded it and they made sure that each staff member
Get the
received a
recording.
copy of the meeting and had an opportunity to submit their comments. So I think that is
That is suffice. That is fair in these circumstances. And that would be really, really fair. So if you can't have the digital recording, you have a voice note, send it through. If you have a WhatsApp group, you can see whether the person has read it or listened to it. It would serve as record that the communication has gone through. There's a question, though, that someone posed that if you don't have the money to retrench the employees, and that's a serious question because it is also borderline of liquidation of the business. But if the business is not staring down the barrel of liquidation and just doesn't have the money to pay the employees retention packages, then an agreement between the parties can be reached and the future payments of these retention packages. Of course, the employee has also the right to claim UIF benefits for being retrenched, but it is a separate matter in terms of the severance package that is. Worthy to point out that the employee is entitled to 1 year for every completed year of service, depending on the industry that you're on, and notice pay if the employee has been given adequate notice of a month. He's not entitled to the notice pay physically, but these severance packages. So one needs to look at what the affordability of the company is in a set of circumstances.
Thank you, Shaun. Shaun, I'd like us to talk for a moment about the 14 days mandatory sick leave if someone has exhibited, if one of your employees has exhibited symptoms of COVID-19. Now, I can imagine it could place a business in a very precarious financial situation if you invest a lot of money into reopening and operate for a short time, and then almost your whole team, because this could happen, needs to be placed on paid sick leave for 14 days, essentially shutting down your business again and putting you as the employer in quite a precarious financial position. What would you recommend in cases like this?
Well, once that situation becomes apparent that one might be infected or someone has been infected with COVID, then obviously that person needs to go in isolation. There is forms that you can apply and submit to TERS for that person for that 14 days to be financially compensated by the TERS fund. But to answer your question more directly, in terms of the company, it would be prudent for the company to make sure that their procedures are in place. Section 24 to 45 of the OSH Act, in terms of the COVID-19 directives, to make sure that the necessary precautionary measures have been taken, first of all. Second, it would then also be prudent for each and every employee to be tested and make sure that those employees are definitely have the COVID or definitely does not have the COVID. In which case, latter, and all employees are reasonably expected to report for duty and then commence with their duties. If they do have the COVID, positively tested, then they should be in isolation for 14 days, and TERS payment of financial benefit would then kick in. In concerning with employees that suspected of being we contact with persons infected with COVID and not able to undergo the test via financial restrictions, the stance some employers have taken is they'll subsidize or pay for their tests. It's a small price to pay for the productivity in the company to produce further. If the company is not in a position to have employees tested and pay for the test, then they should obviously approach the necessary local hospital and clinics for that assistance there.
Thank you, Shaun. What would the situation be if one of your employees was exposed to COVID-19 at your business and subsequently tested positive and had basically contracted COVID-19 at work? Obviously,
then the guidelines of Section 24/6 take into consideration. You need to follow them. Everybody needs to contaminate. You get a certificate from the company that does the decontamination in premises, that it is according to their standards adequately for human occupation again. It also brings us to another prudent question, that if an employee positively knows that he has contracted COVID-19 and he neglects, refuses or fails to report this, to his manager or health and safety officer. And that person can be disciplinary inquiry charged and possibly dismissed because he knowingly infected other people whilst he had to report this position and obviously self-quarantine himself.
Thank you. If an employee is of the age where they can retire, Shaun, and the company has contributed towards a provident fund on the employee's behalf, must the company then still pay the staff member a severance package? Asks one of our participants.
It's up to the discretion of the company. Lots of the companies have made provision for that for the long-serving employee. They can pay them a severance package, but it's not obligated from them when the employee requires to do that. It's also, you have to look at the code of conduct of your company and your employment contract. If your employment contract stipulates that upon retirement, your severance package is applicable, then you should pay such.
Thank you. Shaun, I just want to go back to our previous discussion about the contracting of coronavirus at work. Is there assistance from the Compensation Commissioner for this?
As far as I understand, there is a form that you fill in for TERS for financial benefit. Whether the payments are in time is a question of fact. There is a provision that you can claim that for the period of time that the employer is off. In the absence of such, it has been advised or suggested that the employers pay the sick leave for the employee who has been contracting COVID or has contracted COVID, and then he needs to self-quarantine for 14 days, and the employer needs to pay that. If the business is unable to perform or in restriction powers, it's also an impossibility of performance, and hence that request or that form that now is in place where you can apply for that relief on behalf of the employee. Previously, it was the stance of government that the employer should pay the full sick leave benefits, but the argument is also to the narrative that if the company is unable to perform its duties and unable to operate financially and under the restrictions protocol, it's impossible to pay those benefits, and therefore that protocol was released that you can apply for that TERS benefit.
I understand. And I think going forward, this might lead to a lot of discussions around any communicable disease, especially in our industry where we work so closely with our guests, whether it be in a tour bus or in a convention center, in a hotel, in a restaurant, any communicable disease that one might give to your guests or get from your guests, we maybe need to look at more closely how we deal with that and how we have the financial reserves and government schemes to assist us through such incidents.
Now, of course, and that's where the insurance industry would also play a pivotal role in the future for policies and products that they can develop for this in the future. It obviously will come with a premium. They will play a pivotal important role. Obviously, legal responsibility, all clients or guests entering into any premises needs to declare on a form that they are, according to their understanding, or not suffer from any other disease that's transferable or specifically COVID. And that record has been kept for instance, for insurance purposes in the future. I think that's where the insurance industry will play an important role in this.
Once we've finished our first battle with them.
Indeed, once the battle has been won.
Shaun, our next question, what about the rest of the team that worked with the employee that contracted coronavirus? Do they need to go into isolation? And will that also be sick leave, and will TERS pay their sick leave too? Well,
first thing, they need to be tested, find out whether they are exposed to COVID, and then this results will dictate whether they should go for extended period of isolation. But protocols would dictate that they should immediately go then for an isolation, depending on operational requirements of the company. If it's possible for them to work from home, then they should work from home. If it's not possible for to work from home, and then a different scenario kicks in. And TERS benefits will then obviously pay, because you need to apply a certificate and then that application form and submit to TERS for that financial benefit and a sick leave. If the company is able to assist the employee and has sick leave available and funds, then they are willing to pay it, and they can assist the employee to pay it without the employee waiting for the TERS fund to make that financial benefit.
Okay. I think what's important, obviously, is to have your staff on 2 or 3 different shifts if you can.
Correct.
So if one shift does get infected, it doesn't affect your entire business, and also to disinfect the premises properly between shifts.
Further to point out, I mean, it's important for every business to adhere to the protocols laid out in the hospitality industry and any other business in terms of Section 24 to 45 of the Occupational Health and Safety COVID-19 directives.
Yes.
If you follow those directives and you're fully compliant, even if there is someone is tested positive for COVID, you decontaminate to make sure that the employment environment is safe and the employees cannot unreasonably refuse to tender their services. The test is objective of nature based on the facts on the table. And if the company is compliant with every aspect, then they have to tender their services and continue with the employment.
Right. Our next question, Shaun, does the severance package due for employees who work more than a year or even less? I suppose, is a severance package payable for employees who have worked more or less than 1 year?
The general rule is according to the terms and conditions and the Code of Good Practice Schedule 8 or 9 is 1 week for every completed year of service. So as a person has completed 1 year of service, is entitled to 1 week's severance package. Of course, a lot of companies, and it's not a hard and fast rule, but a lot of companies say that if you completed 2/3 of a year, then we consider it as a year. 2/3 of a year is a year, but the rule says 1 completed year.
Thank you. And last question before we wrap up today. If an employee chooses to quarantine themselves without a sick note, will it be unpaid leave and should it be claimed from UIF?
That directly then should be claimed from the TERS. A sick note can be obtained from a medical practitioner and saying that possibly contact with COVID. If it's a registered medical practitioner within the ambit of South African jurisdiction, then it should be accepted as such. And then obviously the application can then be made for the financial benefit for the employee to receive from the TERS fund. If the medical certificate is of the nature of defrauding or false, then the company can report this as such, also at the relevant authorities, and or can initiate disciplinary action against the employee because he's grossly been dishonest surrounding the circumstances of it, because it's severe consequences. If one says you have positively COVID, and everybody undergoes tests, and oh, sorry, I made a mistake, and he knew, and you can prove that he knew about it, and he deliberately misled the company, and disciplinary steps can ensue.
Thank you, Shaun. I think this is such a difficult situation for all of us. We would all like to retain our very experienced and treasured teams, and how to do this successfully through the rest of this crisis, which is only worse at the moment and doesn't seem to be improving at all, especially with the ending of the TERS fund. It's going to be very difficult, and I think you've given us a lot of guidance on options today. So thank you very much for that. We really value your time. I'm going to bring the session to an end today. We have posted Shaun's direct contact details in the chat section.
Yes, you can. My details and notes of today's meeting will be available on my app. I've developed a Labour app in your pocket that empowers every business owner to access his cell phone, get the relevant information, get the details he needs, documents he needs to download, as well as on-time real case law. You can read CCMA cases, get the specific merits of what your situation dictates, and make real-time decision-making. I'll download particular notes for everybody's access and also to all the panels and people that's registered for our webinar.
That's excellent. Thank you so much, Shaun. We've got a few minutes left, and I'm going to take the last 2 questions that have just popped up here. One is, to be clear, should an employee test positive, do all employees go into 2 weeks isolation immediately, or do they just get tested and then return to work if negative?
Get tested, it will be prudent for them to be tested first, and if they're negative, they return to work. It is also an obligation of the company to make sure that the working environment is safe, and normally decontamination processes need to be followed, and make sure that the working environment and workplace is being taken care of. So no further possible reinfections or possible future infections can take place.
Thank you very much, Shaun. And then a question that's not related to the HR matter, but is very also a burning question at the moment. Are you aware of any class action against the insurance industry for not paying business interruption policies for the pandemic? And I'll answer that. The Tshwane Tourism Association is working together with Insurance Claims Africa. We are consulting with our legal team on Thursday to launch an urgent application. There was a case in Cape Town, which was heard a while ago, and the judgment came out yesterday, and the judgment was in favor of the insured party. That sets a good precedent. It will no doubt be challenged in court by the insurers, but we feel that we've got a very good and strong case, and we are hoping that we're going to launch an urgent application either later this week or next week. And so please do contact the Tshwane Tourism Association office if you would like more information about joining that lawsuit. And then
I just would like to thank everybody there, Bronwyn, yourself, and Nico, in making this possible for everybody to have informative session and real-time decision-making. I know it's been a difficult time and everybody is under tremendous financial strain and uncertainty. These people out there that will be able to give you some guidance and assistance. Thank you very much, Bronwyn and Nico, for your time.
It's absolutely our pleasure, and we really appreciate the time you've given us and the resources you're making available for everyone. I would highly recommend making use of your app. We have got some more questions coming up, but because we're out of time, I'm going to ask you, Shaun, if you can type the answers to those questions in the comments section or in the Q&A section once we've completed the webinar. And we will share a recording and a summary of this webinar and the questions and answers and the notes after the So thank you very much, and thank you to all the participants who joined us this morning. Very interesting topic which will evolve, and we will bring you more information as things do evolve. Thank you, Shaun, and thank you
very much
for assisting us to get this information out there. And
thank you, Shaun.
Thank you.
Thank you.
Take
Goodbye.
care. Bye.